Good morning, good afternoon, good evening, wherever you are around the world. My name is David Wilkins. I am the faculty director of the Center on the Legal Profession here at Harvard Law School. And it is my great honor to welcome our distinguished participants and our incredibly distinguished audience from all around the world to this webinar on global disability cause lawyering, perspectives from leading lawyers in the movement. I can't imagine a more timely or important topic because each of those aspects of the title of our webinar and that first part of the title have never been more important. So take the word global. We are all just going through and hopefully emerging from a global pandemic that has affected people all over the world and shown just how interconnected our world is. And right on the heels of that global phenomenon, we are now all watching the tragedy in Ukraine unfold before our very eyes. And that tragedy, whatever one's stance on it, is going to create horrendous casualties on all sides, which will increase the number, sadly, of persons with disability who will need support and protection. Which leads to the second part of our title. Persons with disability are becoming appropriately more visible, and their rights and entitlement to inclusion more important all around the world. And I'll just say thanks in part to our principal organizer here, Michael Ashley Stein, whose work and the work of his center has played a tremendous role in raising the visibility of these important issues. But these issues are, of course, part of an even broader move towards diversity, equality, access, and most importantly, inclusion for all groups around the world. And this movement, of course, crucially depends on the last part of our title, lawyers, particularly cause lawyers, who commit themselves to making the promises around the world around inclusion, access, democracy, accessibility, making those promises real. We have seen over and over again that the role of these dedicated cause lawyers has never been more important in making the promise of the rule of law real. So as I said, the timing of this important event could never be more important, and it comes on the heels of almost the 10-year anniversary of when I had the great pleasure of working with Professor Stein and Professor Waterstone on an article around disability cause lawyers. But so much has happened since then. And it's so important for us to take stock on what that movement looks like in a global context, which quite frankly, we really didn't talk about in that initial article. And particularly after the important passage of the UN Convention on the Rights of Disabled Persons. So let me just give you a little insight into what we'll be doing today. We have, as I said, an incredibly distinguished group of participants. I'm going to begin by introducing the person, as I say, who is most responsible for this, which is Professor Michael Stein, who his organization is the co-host of this event, the Harvard Law School Project on Disability. And we are also very honored to be co-sponsored by the International Legal Studies program here at Harvard Law School. Professor Stein will offer some brief remarks to frame our discussion here. And then Hezi Smith, who is the fantastic director of advocacy initiatives for that project, will then moderate a panel of distinguished cause lawyers from all over the world. And I will let Hezi introduce them in turn. They will then give remarks, but we will have an opportunity throughout the program for you, our incredible audience, to ask questions which will be put to our participants. And you can do so by using the Q&A function on your Zoom, which I think all of you are probably well familiar now after 2 years of living our lives on Zoom. They will then be fed to our wonderful moderator, Hezi, who will kind of curate the Q&A. But we know we have an incredible audience, and we really do want to include your voices. To that end, we've also done our best to make this conversation as accessible as possible. We have closed captioning, which you can access by clicking on the closed caption button in your Zoom control. And we also have Spanish language translation in captioning as well. And we're going to drop a link in the chat, which you can click on to access that feature as well. In keeping, again, with the important theme here of making everything we do as inclusive as possible. So, with that introduction, it is my great pleasure to introduce Michael Ashley Stein. This is a very emotional moment for me because I've known Michael Stein before he became the Michael Stein who is known around the world. I knew him as a student at Harvard Law School, where he was one of the very first students with a visible disability, not only to go to Harvard Law School, but to excel at the highest levels, becoming a member of the Harvard Law Review, which was completely unprepared, as was most of the rest of Harvard Law School, to deal with a person with a disability. Michael, from the very beginning, made it his mission to change that reality, starting at Harvard Law School, then moving on as a lawyer, where he was the first person to create the National Disabled Bar Association, then as an academic, where he wrote on a number of topics, but really became a pioneer in writing about scholarship around persons of disability. And finally, as the co-founder here at Harvard Law School and a visiting professor since 2005 of this incredibly important center on disability that has been so transformative around the world. As most of you know, Michael was instrumental in the drafting of the UN Convention on the Rights of Disabled Persons. And he has consulted widely and extensively with governments, with NGOs, with private organizations all around the world. I think I travel a lot until I bump into Michael and he tells me the 15 countries that he's been in the last month, all of which he visits in order to assist those on the ground in furthering these important issues. So again, it humbles me to have the opportunity and the privilege to introduce to you one of the leading advocates in this area, but I would go further and to say one of our leading lawyers and scholars and human beings, keeping us on the best of our traditions, Michael Ashley Stein. Michael, please give us your opening remarks.
Well, thank you ever so much, David. I don't know that I could live up to your kind introduction, but I will try every day to do so. On behalf of the Harvard Law School Project on Disability, we'd like to welcome everyone and to thank our co-sponsors, International Legal Studies and the Center for the Legal Profession. We'd like to extend our thanks to Brian Fong and Dana Walters of CLP, to Hezi Smith, who'll be with you in a moment, and to Juliet Bowler from HPOD, and most of all to my friend, mentor, colleague, co-author, and role model for over 3.5 decades, Professor David Wilkins, who has taught me so much on so many subjects. And if in any way I have mentored or moved forward the idea of social justice for the group of persons with disabilities and others, I'm merely following in his path. I have learned so much about cause lawyering from David, and in turn, he has passed on what he learned from his mentors, including the great Thurgood Marshall and his father and uncle and their network of civil rights lawyers. So I'm indebted to you, David, and you have always included persons with disabilities in your civil rights work and your inclusion work way before the CRPD, and I'm grateful to you for that. Adopted by the United Nations in 2006, the Convention on the Rights of Persons with Disabilities has inspired a new generation of lawyers to assist clients with disabilities seeking remedies for human rights violations before local, national, and international bodies. I was honored to have participated in the CRPD's negotiations, and since then I've been privileged to work on its implementation around the world, including physically in 40-something countries and virtually now in many others. While many of cause lawyers narrowly advocate for their individual clients' rights, others endeavor more strategically to bring cases that will advance systemic CRPD implementation for the broader disability community. And it's a big tent, and there's more work than any of us can do in our lifetimes. And so I hope that this continues. Strategic litigation or cause lawyering to advance the human rights of various groups based on their identities, including disability, race, gender, nationality, faith, and so on, or on thematic issues cutting across populations like economic, social, and cultural rights, or poverty, which has an amazing impact across all groups, has been extensively studied. However, the complex dynamics and considerations that inform disability-specific cause lawyers remain almost unexplored. And frankly, the development of disability-specific cause lawyers around the world is still in its nascent stage. There was one and only one disability-specific cause lawyer in Finland, and he just retired. So it is both a growing field and also one that is filled with opportunities, and one that is filled with opportunities as well for allyship, for connections to other groups of similar-minded individuals. For example, the Economic, Social, Cultural Rights Network of Lawyers and others. There are opportunities for us to join forces and to work together. But of course, cause lawyering is not restricted to strategic litigation. It's a very important part, and you'll hear about some strategic litigation today, but it's only one tool among many. Here at HPOD, over the last 18 years, we have intervened in high-impact litigation at the European Court of Human Rights, the Inter-American Commission, and national-level Supreme Court and constitutional courts, as well as a few US ones as well. But mostly we have engaged in other forms of cause lawyering, including domestic constitutional revision, law reform and drafting, policy creation, United Nations programming on the ground, academic research, because we are an academic institution, and most of all, empowering persons with disabilities themselves to claim their human and civil rights. Each of these activities has to be done in ways that are legally, culturally, and resource appropriate for those locations. And they must be done with humility and in response to local priorities. We serve our clients and reflect their needs, and we're very honored to do so. I could cite many examples with a lot of pride, but in the spirit of this event, I'd like to shine a light on just a few significant outcomes that our own Hezi Smith, who will be moderating the panel and the Q&A, achieved in Bangladesh, where he was resident for several years. I'm holding up in front of you a book. It's the first public interest litigation manual in Bangla about persons with disabilities and their rights. And it arose after raising awareness among the country's premier public interest firms, BLAST, and the premier NGO, BRAC, that their work needed to include persons with disabilities if it was to be just and socially just and include all populations. The result was a series of cases, including those lodged at the Constitutional Court. In addition, Hezi led an effort to train local officials and disabled persons organizations about using the revised national disability law to bring about and implement disability-based discrimination actions across the country, with the result that it's people with disabilities themselves who are pursuing justice. Today's event will present a window into various dynamics of cause lawyering by describing the efforts of litigants and those pursuing justice through other means around the world to advance protections for persons with disabilities and their human rights in international and legal and local fora. The panel is comprised of valuable friends and colleagues from 4 different continents and with very different perspectives and agendas. I'm so very proud of this event and grateful to our friends at CLP for moving it forward. And now it's my pleasure to turn over to HPOD's Director of Advocacy Initiatives, Hezi Smith. Hezi.
Thank you very much for those kind words and that kind introduction. I'm really excited for today's panel. We've got a bunch of different perspectives from a lot of different places and long and storied careers of just disability cause lawyering. First up, we have Maria Soledad Cisternas Rias, who is the UN Special Envoy of the Secretary General on Disability and Accessibility. She is a Chilean disability rights attorney and the former chair of the CRPD committee. After her, we'll hear from Janusz Fiala, who's a lecturer at the Center for Disability Law and Policy of the National University of Ireland, Galway, and has been involved in a number of impactful cases at the European Court and the CRPD committee, in which HPOD has had the privilege of participating as well. Then we'll hear from Sanjay Jain. He's the principal of the ILS Law College in Pune, India. And he has a long and storied career in making the Indian legal education more disability inclusive and more creating pathways for younger attorneys with disabilities to make their mark on the Indian legal system. And then last but certainly not least, we'll have Elizabeth Kamundia. She's Assistant Director at the Kenyan National Commission on Human Rights. And she'll be talking about how some of the Commission's work reflects some of the themes that we'll be discussing on disability cause lawyering in the era of the CRPD. And so first, I'll hand it over to Maria Soledad. Maria, ¿puedes empezar?
Yes. Thank you very much for the invitation to participate in this interesting event. And I would like to present my video with my opinion about the topic of this event. And this is my reasonable accommodation. Thank you very much. And please, video.
So Brian, can you take us to video? Great.
In my professional experience, I have handled several trials. For example, accessibility to transportation, accessibility through sign language on television, different forms of discrimination, discrimination against persons with psychosocial disabilities, among others. This corresponds to the path judicial litigation as a means for visibility and change. In this sense, I have verified that even a negative judgment for persons with disability can move the public opinion against the unfair sentence, increasing the awareness raising and producing the desired change, not only for the appellant, but also for other persons with disability who might be in the same situation. The role of the strategic lawyer will be key to make this issue visible and maintain the growing interest in the legal cause. The strategic lawyer must have conviction and persistence. For example, when I sued a national airline on discrimination for refusing to board passengers with disability who did not have a companion, the court decided not to intervene because the issue or the matter is between private parties, airline and the person with disability. For this reason, I appeal to the Inter-American Commission on Human Rights against the state to protect the defenselessness to persons with disabilities. The outcome of this legal action of unlawyering was a change of the air traffic regulation in Chile in relation to passengers with disabilities. A second path is the legal political incidence or impact for normative changes. I will exemplify for the field of political rights of persons with disabilities. A previous precedent is the trial in which I sued the person in charge of a Chilean electoral precinct prevented a blind woman to enter in to vote with her trusted assistant, violating the constitutional and international human rights to vote freely, equally, and effectively. It was in the presidential election 2005. The court declared itself incompetent to hear this case because in its concept there is a legal vacuum. The advocacy strategy began in legal and social research to provide guidelines on the amendment to the Popular Voting Act to facilitate the vote of persons with disabilities, eliminating barriers. As the author of this research, I disseminated this study in the academic sector and the Chilean parliament, followed by a legal and social project for persons with disabilities and voting rights, training to electoral service officers, training for persons with disabilities, and the production of TV spot. The described work resulted in the amendment of the aforementioned law recognizing the right to assistance in the act of voting of persons with disabilities and oral rules of accessibility, year 2007. I believe that our professional work does not finish in the processing of the trial, but must transcend to guarantee rights and not favors, seeking to achieve changes for a greater number of persons with disabilities. 16 years after the case on the right to vote, undoubtedly persons with disabilities are participating more and more in the electoral process, which, added with the validity of Crpd, they demand to be candidates in popular elections. In the process of the elaboration of new Chilean constitution, to guarantee reserved quota for persons with disability in the list of political parties was relevant. In the Constitution, Legislation and Justice Committee on the Senate, there was resistance to this quota. I elaborated an argumentative paper for the constitutional reform that justified this quota, making clear that the commitment of Chile with the ratification of Crpd and other instruments is very strong. The specific result of the oral presentation before the Senate Commission was to get the quota for persons with disabilities in the list of political parties or coalition of parties. If a list does not comply with this percentage, the sanction will be the complete elimination of such a list throughout the country. On the other hand, within the framework of the drafting of the new constitution, I proposed to the Emancipating Circle of Women and Girls with Disabilities, Simonidis, to present a popular norm of constitutional recognition of persons with disabilities and their rights from the approach of Crpd, based on the axis of legal capacity, universal accessibility, the right to independent living and to be included in the community, plus public participation. Popular initiative required a minimum of 15,000 supporters via digital means. On February 1st, the deadline, we achieved the support of more than 16,000 citizens. On March 9, in accordance with the protocol of the Constitutional Convention, I defended this proposal before the Fundamental Rights Commission. Approximately 2 more weeks, we will have the result of this work, hoping that the regulation on disability will be incorporated in the new Constitution of Chile. In summary, both paths, trials and legal incidents are efficient for the 21st century necessary changes in human rights. I recommend that law school train the students for both approaches.
Thank you so much, Maria Soledad.
Thank you very much. And I wait the questions when you said.
Excellent, thank you. Let's turn it over to Janos Fiala, and we'll come back to you, Maria Soledad, after the panelists do their opening remarks for the moderated discussion.
Okay.
Janos, the floor is yours.
Thank you, Hazi. I thank for the organizers for convening such a great panel. I'm very honored to be here. So thank you, Professor Wilkins, Professor Stein, distinguished colleagues, and dear participants. Today, I will be talking about some of the difficult decisions cause lawyers have to make in their work. And I would like to show a few examples from my own practice. What are the different interests which we have to take into account when pursuing certain strategic goals? By cause lawyers, I understand lawyers who have a larger strategic goal in their mind when representing certain clients and who are actively pursuing these goals. Sometimes the client's goals and the larger strategic goals can be in alignment, and that's a very good situation, but often they are not. And so cause lawyers have to somehow balance the goals of the individual client against the goals of the movement. And already here we have a major problem. We don't know for sure what the movement's goals are. Sometimes there is no unanimity. Sometimes the goals are disputed. Think about questions like involuntary treatment. Many people would like to see it abolished. Something that's a goal which is easier to achieve would be improve involuntary treatment. And already there we have discrepancy even within the movement. And then when you are representing a certain client, you have to make a decision what strategic goal to pursue here. But the CRPD, I think, helps in this respect. It gives us kind of a vague idea of what the movement's goals are. So what we have in the CRPD, of course, not everything is clear, but it gives us a good idea of what those goals are. So let me give you a few examples of how the movement's goals can conflict with individual clients' goals. For example, in the area of inclusive education, many in the movement would like to see fully inclusive schools, no separate education. And to pursue this goal, my organization, the Mental Disability Advocacy Center, decided to take a case on behalf of children in Bulgarian institutions who were excluded from education. The case was quite successful, I believe, MDs against Bulgaria. It challenged the situation of children who were not educated at all. So the case itself is a success. But what you cannot see from the case is that there were other children in Bulgaria at the time who had different problems. So we decided to concentrate on children who were excluded from schools at all. But there were others who were in segregated boarding schools. And there were others who were in mainstream schools, but were not accommodated at all. So it was not inclusive education. And we had to decide whether to include everybody in the litigation or just to concentrate on some children. And we decided it was strategically better to have separate cases for each groups. And I think it was the right decision, strategically speaking, but you can see that from the perspective of clients who were not included in the litigation, it was a very, very hard decision. Emotionally, it's very hard to tell them, no, you have to wait. Now we have to concentrate on these ones. Of course, the strategic goal requires that the international courts give due consideration to every single problem. That's when you have a good decision. That's why we decided to have these cases separately. There is an implicit promise here from the cause lawyer that we will take cases, follow-up cases, which will help the others as well. And it happened here. MDC later had another case, MDS against Belgium on separate education. But initially, it was a very hard decision. Some other examples, for example, from the guardianship context. Many people advocate against guardianship. It's a problematic institution. But the client has one single goal: to get rid of guardianship. If they are under guardianship, they would like their legal capacity to be restored. And any argument which helps them is a good argument. But sometimes when we are taking cases, we have very specific interest in mind. So for example, we want to highlight the lack of legal representation, which clients don't have in legal capacity cases, or just the quality of medical evidence, which is problematic. And we would like to concentrate only on that. Well, of course, the client would like to use any argument which they can. So here we have to negotiate between the client's interest and the lawyer's interest. That's why selecting the right case is very important. If we want to achieve a specific goal with the case, we have to find the right client whose interest is probably the same, or the fact patterns are very similar. Similar example relates to the right to vote. Kisalós against Hungary is quite a well-known case from my career, which established that persons with disabilities should have the right to vote. They shouldn't be disenfranchised without an individual assessment. That's what the court said. But actually, the client had many other issues he was dealing with, which were not possible to challenge with litigation. So here we had to be very clear from the very beginning what litigation can help with and that happened to be something which we had also strategic interest in, and what it cannot help with. And then we could make an agreement with the client what we will be representing him in and what not. Here, I would also highlight perhaps the importance of third-party interventions. Professor Stein already mentioned that. Cause lawyers can pursue strategic interest not only by representing clients, but bringing into the court's attention the strategic interests of the whole disabled community by submitting interventions in cases. And they are not restricted the same way as when they represent clients. So these were just a few examples. I unfortunately don't have time for more, but I think the best strategic cause lawyers could do is to be explicit about what are their interests, what are the interests of the larger movement, and what are the interests of the individual clients. And the interests of their organizations who are supporting their case are also very important here. Those organizations also have stakeholders which are not the same as the movement. Maybe they have donors who are funding the litigation and they have specific interests. For example, publicity of certain cases. These conflicts are natural. We shouldn't pretend they don't exist. But probably the best approach to deal with them is honesty and clarity from the very beginning. So if we are clear with the client from the very beginning, what our interest in the case is, what we would like to achieve, and we tell it to them, that never causes a problem. Maybe the client's interest is something else, and we will not have a case together. But this is way better than pretending that our interests are in alignment with the client's and have a conflict later when we are about to have a major decision. Thank you very much. These were my few examples.
Thank you, Janos. That was great, and you jammed a lot into just a few minutes. So we'll come back to you, but for now, I'd like to turn it over to Sanjay. Would you care to share your thoughts on global disability cause lawyering from your context?
Thank you very much. I want to thank Professor Stein and all other friends for giving me this wonderful opportunity to speak to my mind about disability cause lawyering. What I want to do is basically to maybe respond to some of the examples in Maria's presentation, and then maybe have a comparative perspective. What is the position in India? And maybe I would also respond to the piece, wonderful piece, written by Professor David Wilkins and Michael Stein, which really helped me to understand the concept of disability cause lawyering. Now, firstly, what is exactly meant by disability cause lawyering? Can we have a cohesive definition of disability cause lawyering? In my opinion, we may not, because the conception of disability cause lawyering has to be contextual. It depends on the time, place, and the legal culture. For example, when I read the piece of Professor David Wilkins and Michael Stein, they emphasize that disability cause lawyering in USA essentially is in lower federal courts or the lower courts in the states. Whereas when I look at the disability cause lawyering, in whatever nascent stage it exists in India, I find it evolved mainly, predominantly by high courts and the Supreme Court of India. So Supreme Court of India is the apex court. And it was really extraordinary to read from the piece the kind of pessimism disability cause lawyers in US had in terms of the take from the US Supreme Court. And that is true, because I think US Supreme Court has virtually superimposed its understanding of disability on the text of ADA, resulting in 2008 amendments as a response from Congress. So therefore, there is a radical difference. Now, this radical difference becomes more interesting when I compare the legal regimes of India and US. For example, in US, we have a comparatively cohesive law, comparatively detailed legislation on disability. Whereas in India, our constitution is deeply ableist. Disability figures in terms of perpetuating disqualification regimes. As a subject matter, it is very awkwardly sandwiched between burial grounds and intoxicating liquor in the state list. And to my surprise, and to the surprise of, I think, all academics, none of the states in India has really tried to legislate on the disability rights, despite disability being a state subject. And therefore, unlike US, we have a central law enacted by the Parliament of India, both in response to the disability causal hiring movement and to fulfill its international treaty commitments. And from this perspective, when I look at the role of judiciary, it is really commendable, because despite a ableist constitution, despite the fact that constitution is explicit in not providing physical and mental disability as one of the grounds of non-discrimination, judiciary has produced some phenomenal judgments. Again, comparing US and India, most of these judgments have come in India in the domain of employment. Whereas in US, disability cause lawyers tend to hesitate to take employment cases because, according to them, employment cases do not generate structural reforms. Whereas in India, National Federation of Blind, mainly through S.K. Rungta, who may be regarded as one of the disability cause lawyers, he has brought most of the cases through the National Petition of Blind in the domain of employment. And while dealing with the employment rights, court has used the broad canvas of constitutional rights to superimpose, to inject the international law spirit into the Constitution of India. So unlike unlike Chile's court, which talked about legislative vacuum, Indian Supreme Court or High Courts, they recognized vacuum and they tried to fill the vacuum by using international law. So in this way, I think India has achieved phenomenally, but mainly through judiciary. Now, when we talk about cause lawyering is not only about filing cases, but it is also about lobbying for reforms in law, lobbying to have better regulatory regime, to educate various sectors, to make people realize how stigmatizing effects can really subvert the lives of people with disabilities. So consciousness raising is, alongside litigation, consciousness raising is another important avenue of disability cause lawyering. And I think in India, alongside litigation, a number of civil society organizations dedicated to the empowerment of people with disabilities, they are doing a bit in terms of consciousness raising. Now, let me give some examples, because I have to justify my claim, how Indian Supreme Court and High Courts have really performed their post-colonial transformative role, and how they have scored a fair amount of points for the comparatively institutionalized courts in the West. Now, if I were to take a few examples, the first important case which I remember is a case called Lalit versus National Capital Territory, Delhi. Now, this case was brought by certain blind people who had completed their education in a blind school, and still they wanted to continue to reside in the hostel of such a school, because of a lack of shelter. And the argument of the state was that over the right to shelter of the adult residents, blind residents, the right to education of the children who are still continuing their education should prevail. And therefore, the matter went to the court. These adult adults, they went to the court pursuing right to shelter. Now, Delhi High Court, invoking the principle of intersectionality implicitly, held that when it comes to younger disabled children, they are in a much vulnerable, their position is comparatively more vulnerable, because they are both children as well as they are disabled. So the aspect of operation, the disparate impact because of they being children compared with adult, was highlighted by the court, and the case was decided in favor of children, taking into account the limited resources of the state. Another interesting judgment I recall, which has been recently delivered by Justice Chandrachud in Vikash Kumar. That judgment is phenomenal in the sense that Justice Chandrachud has categorically held that right to reasonable accommodation is not merely a slogan. In fact, the right to equality vis-a-vis disability is contingent on attainment of right to reasonable accommodation. So the individualization of justice, which is very important, because reasonable accommodation as a institutionalized principle to be practiced by the Indian state while dealing with people with disabilities. So structurally, I think Vikash Kumar is one of those cases which offers a very important blueprint, very vital blueprint for evolution of disability cause lawyering. So I think I've had my say.
Yes.
Thank you very much. I was happy to take questions.
Sanjay, that was excellent. Thank you so much for those cogent thoughts. I would just like to turn it over now to Elizabeth Kamundia for our last formal presentations, and then we'll get into a discussion. So Elizabeth, the floor is yours.
Thank you, Hezi. Thank you for that, for your introduction. My name is Elizabeth. I work at the Kenya National Commission on Human Rights, and I'd like to thank you, as well as Professor Stein and the entire team at HPOD, for the invitation. It is a pleasure to be part of this panel today. Now, the Kenya National Commission on Human Rights, where I work, is a national human rights institution that is set up in accordance with the Paris Principles and is the monitoring agency under Article 33(2) of the UN Convention on the Rights of Persons with Disabilities. Lawyers in the Commission may not strictly fall under the title of disability cause lawyers, as defined by the Waterstone, Stein, and Wilkins et al. Article on disability cause lawyers, to mean lawyers who primarily engage in litigation on behalf of people with disabilities, as opposed to lawyers whose main efforts were on other types of advocacy. Our efforts at the Commission are spread across many types of advocacy, as is required under our constitutive statute. These include reviewing and making recommendations to Parliament on the compliance of domestic laws with the Convention on the Rights of Persons with Disabilities, following up on the implementation of relevant concluding observations from treaty bodies, as well as training and capacity building of policymakers on the UN Convention. But having said that, I would like to reflect on two cases that the Commission has been engaged in to promote and protect the rights of persons with disabilities. Now, the first case is the Rose Ajwang and Another versus the Holy Ghost Coptic Church of Africa. And this case involved a minor. It was a young man, 17 years old, who had with a psychosocial disability, who had been held at a church for faith healing. When our team visited the church premises, the minor was shackled at the church. And by shackled, I mean the practice of confining a person with a psychosocial disability using chains or locking them in a room or a shed or other sort of shelter, as was described by the Human Rights Watch in their global report on shackling in 2020. And so the Commission brought a case against the lead pastor and the church, contending that the church had denied the minor freedom of movement and liberty and violated his rights to health, education, and freedom from torture, cruel, inhuman, and degrading treatment. We also enjoined the county government and the cabinet secretary for health in the suit for failing to reprimand the pastor and the church and for failing to put in place appropriate measures to address issues of persons with psychosocial disabilities. The court found that the removal of the minor from the school and his confinement at the church amounted to psychological torture, but oddly, it did not consider the act of being shackled itself as torture. The court also found a violation of the right to education and freedom of movement and imposed a fine of about $5,000 on the church and its lead pastor. However, the court found that the relevant county government had provided medical support and facilities for the treatment of people who suffer from mental illness, in the language of the decision. So now, as a commission, of course, we recognize that the interplay between litigation and social change is quite complex, and that winning a case, and in this case, really, it was more like a half win because we were really keen on the county government being held responsible for failing to provide quality mental health services. And we were also very keen on the judgment reflecting progressive provisions of the CRPD based on the submissions that we had made, but this unfortunately did not happen. Still, the point is that winning a case of this nature is one thing, but if the circumstances don't change in terms of stigma, in terms of the horrendous conditions in which people with mental health conditions find themselves within state mental health facilities, then we will simply have other settings cropping up to provide the missing services or to meet the unmet needs. And so for this reason, following up on this case, we have been very engaged in the review of the Mental Health Act of 1989 in collaboration with persons with psychosocial disabilities and their representative organizations, and in particular advocating for the protection of people with psychosocial disabilities from use of seclusion and restraints in all settings, and advocating for the provision of community-based mental health services. We have also urged in the review of the Persons with Disabilities Bill that healthcare services should only be provided to persons with disabilities on the basis of their free and informed consent, and that these individuals should not be concealed in a manner that would hinder their access to services or their exercise of human rights. So we are very engaged also in an ongoing survey that is led by the National Statistical Office and the Ministry responsible for disability that is aiming at documenting the support needs of persons with disabilities, including persons with psychosocial disabilities, and the extent to which these needs are met or are not met, with an overall aim of facilitating planning and implementation of particularly Article 19 of the Convention. Now, the second case I would like to highlight is an ongoing case petitioning for the decriminalization of attempted suicide in Kenya. In the Kenyan context, people with psychosocial disabilities have been disproportionately affected by Section 226 of the Penal Code, which makes attempted suicide a misdemeanor that's punishable by imprisonment for a term not exceeding 2 years. I would like to use this case to demonstrate how we have coordinated with disability rights organizations and other allies. So as a commission, as a national human rights institution, we convene a civil society stakeholders forum on mental health. And one of the things we've been keen on is law reform to advance rights of people with psychosocial disabilities, which we have been engaging in relation to the Mental Health Act, as explained earlier. Now, other laws that disproportionately affect people with psychosocial disabilities are criminal laws, and we've been engaged in law reform processes on this front as well. In the decriminalization of suicide case, the commission is a petitioner alongside a person with a psychosocial disability and an unlikely ally, the Kenya Psychiatric Association. A coalition of organizations of persons with mental health conditions is an interested party in the case as well. We've engaged people with psychosocial disabilities actively in the case, including in decision-making as to whether to go the parliamentary route or the judiciary route in the goal of decriminalizing suicide, as well as reviewing draft petitions and draft affidavits jointly. So the case is ongoing, and we are excited to see how it unfolds. I think overall, I'd like to emphasize the concept of allyship and the multiple opportunities to join forces and work together across, different sectors and different stakeholders. Over to you, Hezi, and thank you.
Thank you so much, Elizabeth. And thank you to all of the rest of the panelists as well. Maria Soledad, Sanjay, Janos, would you like to come on screen so we can have a kind of a broader discussion? I'd like to highlight some of the themes that you have touched on and put your remarks into into dialogue with one another. Elizabeth, starting with you, since you're still warmed up. I really liked how you were kind of talking about how you're coordinating very closely with, in this current case, with allies, and including some unexpected allies, the Kenyan Psychiatric Association, in order to decriminalize attempted suicide. I would love to hear a little bit more about how that kind of strategic issue came to the commission's attention, because as Janos was saying, the CRPD is a good kind of indicator of what the disability rights movement's goals are. It's one reference point. I don't know that the CRPD talks explicitly about attempted suicide and decriminalizing that as a kind of movement goal. And I would love to kind of hear a little bit about how that kind of goal was identified. And then, Janos, after we hear from Elizabeth, I would love to kind of hear some of your thoughts and reflections, because there's, CRPD doesn't have it all figured out. There are other movement goals that arise, and maybe you could speak to some of what you've seen in your practice, kind of where other movement goals get identified and how those get identified beyond referencing what's written in the CRPD and the case law and the guidance that's developed by the CRPD committee. So Elizabeth, that's a big old question. I'll turn it over to you, and then Janos, I would love to hear your reactions. And Maria Soledad, Sanjay, if you want to jump in after that, please feel free to. So Elizabeth?
Okay, so thanks, Hezi. So sometime in 2020, the president set up a task force on mental health, basically to examine the status of mental health in the country and make recommendations in the wake of, a series of issues and a series of reports highlighting the dire situation of mental health care in the country. Now, the task force initially actually did not have a user in it, and the commission was key in advocating for the inclusion of a user within this task force on mental health. And that advocacy was successful, and eventually the task force had membership of a user in it. Now, some of the task force report makes a broad range of recommendations, one of which is the decriminalization of attempted suicide. And the argument given for this is that this provision targets unjustly people with psychosocial disabilities, and also that having this in the law limits, help-seeking behavior, and just generally has a negative impact in the issue of access to healthcare services by people with psychosocial disabilities. I think we felt as a commission that it was a pretty sympathetic case in a way that, it was sort of like a low-lying fruit in terms of the broad range of recommendations made by the task force. And seeing as the Kenya Psychiatric Association also agreed with this position, as did users and the movement, people with disabilities, we said, let's begin here. Let's go with this, less, contentious, so to speak, issue. So that's how that came about.
So Janos, kind of some reactions to that, and maybe also whether it's fair to say, as Elizabeth was implying, that disability cause lawyers are all about choosing the easiest possible case, which is not what you said, Elizabeth. I'm just having some fun.
Yes, thank you. It's a complicated question, so I'm not sure it's always the easiest case. But just by disability lawyers being involved, it definitely shapes the goals movement in a certain way, of which they are often not aware or not as explicit as we would like them to be. So just going back to a bit more general question of what you asked before, and I will get back to this, is the CRPD the same as the goals of the disability rights movement? And maybe in a very general level, it is. You can kind of read into it everything, or maybe almost everything which the movement would like to achieve. But that's not so true about the specific immediate goals and how to achieve them, how priorities should be set, and there are a lot of different possible avenues which the CRPD just doesn't resolve. And I have seen discussions where advocates were arguing about legal capacity reform and saying, oh, we need better trained guardians, and we need people who are nicer to persons with disabilities. And as soon as you have lawyers involved in the discussion, then it's always channeled towards, what is possible to litigate before a court. And yeah, nice people, no, it's not a legal obligation, forget about that. But it doesn't mean it's not a valuable goal. But if you restrict the discussion to what's possible to argue before the court, you will have a very narrow understanding of what we are trying to achieve here. That's why it is important, I think, that disability cause lawyers are involved in other types of advocacy as well. And maybe there are other avenues through which we could achieve these other goals, and we don't restrict ourselves to litigation as well. And if it is about litigation, then we are very conscious, explicit about, who is making those decisions, what is a goal worth pursuing, what is not. There are difficult legal questions there, yes, which is an easier case, which is not, what are the possible advantages, disadvantages, but it's not only lawyers who should make those strategic decisions, which I think unfortunately often happens. So there has been criticism from the movement of you're confusing disability movement with the CRPD. One is a legal document, while the other is actually a much broader issue.
Thank you, Janos. María Soledad, tomando el hilo del tema del papel. ¿Sí me escuchas?
Más o menos.
Ah, ok. Pero tomando el hilo del tema sobre el papel de la CRPD como una carta fundamental o una plataforma que identifica como temas para promover y avanzar a través de incidencia jurídica o cosas así. ¿Cómo ves el papel de la CRPD en definir las metas del movimiento o, al contrario, quizás consideras que pues las metas son definidas por las propias organizaciones y la CRPD es un reflejo parcial de las metas del movimiento y los abogados tienen que estar en diálogo con las organizaciones? ¿Cómo lo ves? ¿Qué es el papel de la CRPD en definir las metas de los abogados de la causa?
Okay.
And just to,
Okay.
while you think,
Okay.
just to provide a little translation, I'm asking Maria Soledad, how does she see the role of the CRPD in defining disability rights movement goals that disability cause lawyers should pursue either through litigation or through other forms of advocacy? So, Maria Soledad,
Thank you very
cedo
much.
el uso de la palabra.
Gracias. Thank you very much. In my opinion, CRPD has been the main instrument, undoubtedly the main instrument to define the goals for the work in relation to civil society of persons with disabilities, because in general, the authorities is not a great interest in relation to persons with disabilities. But I would like to emphasize the great strong of the movement of persons with disabilities around CRPD, and precisely the goals come from CRPD, and the organization of persons with disabilities work in relation to these goals. And it is important the concluding observation of the Committee of CRPD of the United Nations, because civil society take this recommendation and work in relation to fulfill this recommendation with the exigibility to the authorities, including the action to the courts to fulfill the goals that propose the Convention on the Rights of Persons with Disabilities. And now, in our moment here in Chile, it is very important the connection, the union, the interaction of civil society of persons with disability, including the organization of psychosocial disability persons and mental health, because we have the process of the new constitution. And we know that it is very important that we will have a common group to push the process in relation to the new convention. I mentioned in my presentation that the access for the new constitution is legal capacity, for example. The right of independent living and to be included in the community. And you know that this rule means different change inside the country, for example, in terms of disinstitutionalization. For this reason, I think that CRPD, I repeat, is our most important instrument to fight in this historical moment. Thank you.
Thank you, Maria Soledad. Sanjay, maybe you could, kind of following on Maria Soledad, talk a little bit about the role of the CRPD in some of the cause lawyering that you've seen in India. Has that changed the game? Has that just been another tool in a tool belt that lawyers have been using for a long time? How do you see the CRPD's role in the Indian disability cause lawyering sector?
Frankly speaking, I don't see UNCRPD as a centerpiece in the disability cause lawyering, because UNCRPD is essentially tailoring the existing human rights to the situations of persons with disabilities. It is not recognizing any new rights. Therefore, UNCRPD may be a medium, and this medium must be deployed to translate the disability rights, to transmit disability rights into the public law of all jurisdictions, including India. So, in my opinion, UNCRPD is a medium. It is a vehicle, right? But the goals of disability cause lawyering can be attained only if we sensitize the public law, for example, of India. That is my first point. My second point is what happens if disability cause lawyering is not institutionalized, like it is in USA. You have National Disability Rights Bar Association. When, for example, in India, most of the lawyers, they take disability cases just occasionally and pro bono. So what about funding? And funding is not all about the fees of the attorney. Funding is also required for generating statistics. Funding is also required for doing research. So in terms of funding, if the cause lawyering continues in a pro bono manner, then fair amount of charitable approach creeps in. And I think that is a problem with most of the developing countries. So, okay, you are doing a lot of cases, so do some pro bono work. So, although you are posing that you are doing cause lawyering, there is fair amount of paternalism. So, that is, and my last point, even if you are able to produce good judgments, what about the implementation? What about the implementation of the judgments? Because judgment by itself does not empower. The judgment has to be followed up. And I think therefore one of the key elements of disability cause lawyering is not, I think, obtaining the judgments. You may obtain judgment. Judges may also try to be politically correct, and therefore they may give good judgment. But what about following up the judgment, and what about seeking the scrupulous implementation of the judgment? And most of the times, I think, the other organs of the state, particularly in developing countries, they fail the judiciary because they don't implement. In India, Rights of Persons with Disability Act, which is a very good law, 2016 law, is totally under implemented. So howsoever big judgments are delivered, howsoever a powerful cause lawyering is done in the courts, if it is not followed up by the pressure to implement, it would be a very perfunctory. Yeah.
Janos, I see your hand raised. You want to jump in?
Yes, thank you. Listening to the very interesting comments of my colleagues just made me want to add a sentence, basically. The CRPD is very important, obviously, and it has played an enormous role in energizing the disability rights movement. But let's not forget that there was disability advocacy before the CRPD, and even legal advocacy before the CRPD. And the CRPD itself, I don't see it as the be-all and end-all of disability advocacy. So let's think about it as a tool, a very useful tool, which also has its limits. And here I want to highlight what Sanjay was saying. If we are relying on the CRPD in legal advocacy, it is because we wanted to see to have an impact. So implementation, follow-up is very important. So that's why all the steps we are doing as cause lawyers, they have to be connected to existing advocacy efforts of a larger movement. Because if there isn't, any advocacy, larger advocacy effort, then a useful case will have very little impact. And that's why in a certain situation, if as a lawyer, you might want to use the CRPD, but if the organizations you're working with have a goal which is not connected maybe to the CRPD, then maybe it's better to use something else, even if legally it would be less advantageous. And let's give you a specific example. The CRPD doesn't say much about how restraints in psychiatric institutions should be regulated, because it simply says, you should not use it. But if you have a movement which is working with mental health professionals about overcoming restraints in mental health institutions, and they ask you to help them litigate certain cases which highlight abuses or even inhuman treatment connected to restraints, sometimes it's not the CRPD what you want to use. And definitely your clients sometimes would be saying, okay, if your only point is the state should not use any restraints, you're not really helping me, because there are better and worse restraints, and we want to have certain standards. So here would be a very specific conflict between goals as defined by the CRPD and as defined by the community which you are working with or working for. And there can be other situations like this, what forum you use. So I just wanted to just double on what Sanjay was saying about the importance of implementation and highlight some of these concerns. Thank you.
Elizabeth, I know you had your hand up, but now it's down, which is fine. But if it's down intentionally, I know we got a question from the audience. And Sanjay, I'm not ignoring you, but I just want to highlight one question from the audience, especially since we have a few disabled lawyers on our panel with us and taking advantage of that. The question is, how can someone with an invisible disability or someone who has a chronic illness, regardless of how that person identifies, how can that person get involved in these spaces and contribute to these actions, especially when there may be some disability related accommodations that that person needs in order to kind of do the work that one traditionally associates with an attorney. Y específicamente para María Soledad, solo para como resumir la pregunta, es más o menos como una persona o un abogado que tiene discapacidad, que quizás sea como invisible, pues puede entrar en este movimiento, este grupo de abogados de la causa y contribuir al litigio o otras formas de incidencia, aunque pues quizás está experimentando algunas limitaciones debidas a su discapacidad. So, does anyone want to take that question? How can lawyers with disabilities get involved, basically? María Soledad, y luego Sanjay.
Thank you very much. Previously, I would like to comment in relation to the role of CRPD, because you know that CRPD has a important group of legal right protected. And in this sense, it is very important to consider the status. And as a lawyer, we know that we have another convention, such as for the women, for children, racial discrimination, torture, etc., etc. At the same time, to add the national legislation, we can combine different arguments, but we know as persons with disability that CRPD is important to us. But the rules about interpretation of the convention, all of them suggest to use the best rule for the subject of law. and I think this is important, in my opinion, to understand. In relation to the organization, obviously, each one has their own goals. I understand, but if they are goals in relation to some right of CRPD, they can make a program with a task to get these goals. This is my previous comment. Secondly, I would like to say that I know different lawyers with different disabilities, including disabilities, invisible disabilities, and they can participate in the movement of these lawyers with disabilities. And I do believe that their contribution will be very important. I know lawyers with psychosocial disabilities, but the main problem for them is to declare in front of the audience that they are disability. Do you understand? Because they feel afraid in relation to discrimination. But in the same way, the lawyers that I know, they are collaborating with the work of CRPD, the cause of persons with disabilities, etc. And we work with the diversity, and we open the doors in relation to our colleagues with disabilities. And if they prefer the confidential character of his or her disability, we need to fulfill this perspective. Thank you.
No, thank you, Maria Soledad. Sanjay, I know you wanted to respond to the question and the conversation.
Yeah. I tend to agree with Maria when she says that there is a fair amount of hesitation. Particularly, there is an invisible disability, and if invisible disability relates to psychosocial disability. But there are other invisible disabilities which are not, which are not at all taken as disabilities by the so-called mainstream. So even if somebody exposes his or her invisible disability, the mainstream would say, okay, it's all dramatization. And therefore, it is important that we appreciate the heterogeneous character of disability movement. Disability movement, unlike lesbian or transgender movement, is very heterogeneous, and there are a lot of countercurrents in the movement. And therefore, the focus must be on stigma. And I think Indian Supreme Court has done wonders. Just recently, it has delivered a judgment adopting the Delhi High Court long 60-page order, holding that a person with bipolar disability can be eligible to be appointed as a judge. And in fact, he has been appointed as a judge. And the court has very clearly said that, okay, when you require treatment, go for it. Everybody requires treatment for some or the other ailment. So what is a big deal? So the court has combated the stigma. Court has combated the myth surrounding the invisible disability. So I feel that we have to team up, both people with visible disabilities and people with invisible disabilities as cause lawyers. They have to team up, and this engagement may produce much more enabling doctrines, much more enabling standards. That's what I feel.
Thank you, Sandra. Elizabeth, 1 minute or less.
Oh dear. Okay. So I just wanted to respond to that question about the contribution that someone could make. And I wanted to say that in your shoes, I will start by making connections with organizations that already are likely to be having cases on issues of disability, including mainstream organizations that offer pro bono services, legal aid centers, national human rights institutions, umbrella disability movements in your country. Trust me, we are always short of researchers. We are always short of people to bounce ideas off, and would be really welcome welcoming to the contribution that you may want to make. Also clarify the specific contribution. Would you like to make a research contribution? Would you like to join an ongoing case with an amicus brief if your country enables individuals to do this? Those would be, sort of some ideas I'd have around that. Thank you.
And just adding on that, Elizabeth, and a couple of your co-panelists have mentioned that, whether strategic litigation or strategic initiatives are ultimately impactful depends not on necessarily the legal arguments or the decisions, but on how those concepts, change attitudes and biases that may exist not only in legal systems, but also in society. And so having folks who can also translate some of those legal concepts into impactful social messaging is also another really important role, and one that journalists often play, but that I think increasingly cause lawyers are doing more education and those raising awareness efforts outside of traditional areas of legal practice. So we have about 5 minutes left, and I would just like to plug, I would like to thank, first of all, everybody on the panel, Maria, Soledad, Sanjay, Janos, Elizabeth. There's a lot to unpack here, and there's a lot to mull over. Thank you so much for your thoughtfulness. Thank you to our interpreters, our captioners, for making this event more accessible to a broader audience. Sanjay, I see your hand up, but I don't know. Please visit us at our website on the HPOD website. Please visit the Center for Legal Professions website to get information about upcoming events. Stay tuned also for a forthcoming issue of The Practice, which will expand on some of these issues that our panelists have highlighted in the global disability cause lawyering movement. And with those remarks, I'm going to turn it over to Professor Wilkins to wrap up and end the event. Professor Wilkins?
Wow, that's all I can say. I had the great pleasure of just sitting and listening and learning to our amazing panelists. Thank each and every one of them for their incredibly insightful remarks, and Hezi, to your brilliant job of kind of bringing it all out and bringing it all together. What is so clear is that, if anything, I underestimated the importance of this event in my initial remarks because of how much it illuminated, again, our three big themes that are part of our title, how much it illuminated how much globalization has reshaped our world and our understanding of lawyering. And again, I know Michael would agree with me that, we could never have written the same article that we did 10 years ago today for everything that we have learned. How much we have learned about how the convention is reshaping the understanding of what the movement's aims for people with disabilities, and the implications of that beyond the traditional understandings of what those concepts meant 10 years ago to what they mean today, to what they are likely to mean in the future. And finally, the many complex and important ways of lawyering that our brilliant lawyers are doing and encouraging others to do. It's just been thrilling. I'll just close again by thanking Michael Stein for bringing us all together. As Hezi said, our incredible sign language and translators who have opened this event up to so many more people, that we can try to represent the inclusiveness that we seek to bring to the world. My own incredible team of Dana Walters and Brian Fong, who've behind the scenes been putting all of this together. And I really urge all of you to continue the conversation, both with Michael at Hezi Center and with our own. As Hezi said, we are going to be publishing an issue of our digital magazine, The Practice, which will address many of these issues and hopefully try to deepen the conversation. But this is really just the beginning of a conversation and a movement that will be so critical to our world going forward. So thank you all for spending this time with us. And with that, I wish you all a good morning, a good afternoon, a good evening, wherever you are around the world, and look forward to seeing everyone again soon. Thank you very much.